fairly long program this afternoon, so I think we probably should get started. My name is Diana Hunt, and I will be chairing this afternoon's program. It seems very odd to stand up here and not welcome you to the program and introduce what the program is about, but my job is to introduce Denise Bellamy, who will introduce the program to you and welcome you to our afternoon. If you have any problems, if you don't have your materials, if your materials are upside down in your book, for which we apologize, would you please see me? And I'll be sitting over here for most of the afternoon and be glad to talk to you. Denise Bellamy was called to the bar in 1980 and thereafter worked as an assistant Crown Attorney for 4 years. She then became the first senior policy advisor for justice issues at the newly formed Ontario Women's Directorate. Denise is currently a member of the Court Reform Task Force, which has been preparing the Attorney General's response to the Zuber inquiry into Ontario's courts. Denise is also one of the only 6 elected women benchers of the Law Society of Upper Canada and is on the recently established Benchers Committee on Women in the Legal Profession. Denise was also part of the planning committee for the very first Women in the Legal Profession program, which was run a couple of years ago. Denise?
Thank you, Diana. It's nice to be back here looking at all these the women and a few more men than we had last time. I think last time there was one man who was a bencher who came, I think, to make sure that we weren't doing anything wrong. And now I notice there are no male benchers here, so either we've succeeded or we haven't. You always know when a movie is a success because when it's a success, at least financially, within 2 or 3 years there's a sequel. So this is I guess, the Continuing Legal Education Department's sequel to Women in the Legal Profession. This is, I think, entitled Women in the Legal Profession Part 2. The first program was in 1986. And just as with the Rambo movies, I think there are about 102 now, Part 102, eventually there should be no demand for this sort of a program. In fact, if those of us can look far enough ahead in our crystal balls, or if we're Pollyanna enough, and I am, I think that someday a program entitled Women in the Legal Profession will appear as bizarre as a program entitled Men in the Legal Profession would appear if we were to have it right now in 1989. Unfortunately, we're not there yet. And I know we're not there yet because the newspapers and the media, the magazines, the law reviews, etc., tell us that we're not there yet. For example, in February 1988, the American Bar Association Commission on Women in the Profession released a report that contained some very damning indictments about the way that women lawyers are treated in the United States. That material is contained in the package of material that you have before you today. Later on that year, in November 1988, the Manitoba Association of Women and the Law released a report entitled Gender Equality in the Courts. You've got all of this stuff in your material. They canvassed the issue of gender unfairness, as they called it, in the Canadian legal system. And they concluded that problems facing women lawyers and clients are really quite epidemic in the courts in particular, because they were looking at the courts. And they're so severe that they have asked the federal government to establish a national task force on gender equality in the courts. The newest controversy to erupt in the media, and one that is certainly capturing a lot of media attention right now in the United States, I hope will be discussed today. It revolves around a 1989 article that appeared in the Harvard Business Review, which sets out what some people argue is a justification for second-class treatment of mothers who are lawyers. Legal mothers? I guess they're not legal mothers. In the article, employers are encouraged to identify and nurture 2 separate groups of women. One is called the career track, or the fast track. The other is called, somewhat derogatorily, the mommy track, which they suggest that the career track should be for high potential women, most of whom will be childless, and treat them just as they would treat talented men. Then they should help those who are on the quote-unquote mommy track to be productive, but probably not upwardly mobile. So to encourage them to either share work or work part-time or whatnot, but not to become partners in the firm the way that they would for the career fast-track women. That's pretty negative, I guess. But despite all of that, I think that there are some respects in which we women and men are in a rather exciting era as far as women lawyers are concerned. For example, half of the women practicing law in Canada today were called to the bar in the last 10 years. Indeed, most of the women lawyers who have ever practiced are living today. I think that makes for a rather different sort of demographics. Obviously, the same thing can't be said for men. Not that we would not want them all to be here today, but we'd certainly have a lot of competition problems, I guess, if they all were. Women are being called to the bar in increasingly large numbers every year, and in fact, this is the one most dominant trend in the legal profession today. It has to do with the number of women entering the profession. It's a trend that is drastically, and I repeat, drastically altering the face of the legal profession in the 1980s. The way in which women are altering the face of the profession has also captured the attention of the benchers of the Law Society. There is now a committee looking at women in the legal profession, and we're examining the effects of the increasing number of women on the profession. We'll be looking at the demographic data and proposing a policy for the Law Society regarding gender issues facing the profession. I anticipate that this will be a very interesting agenda item when it appears at convocation, and I remind you that convocation is now open to the public, so I would encourage all of you to attend on the date that this is going to be discussed. Let me give you just another very little small sort of token gesture showing of how women have changed the face of the profession. In 1897, less than 100 years ago, Clara Brett Martin was the first woman in the Commonwealth admitted to the bar. Next week, I and Diana and a few others who are here will be moving into a new building for the Ministry of the Attorney General at 720 Bay. That new building has been named the Clara Brett Martin Building. Now, I know that this is a fairly symbolic gesture, but I know that that would never, ever, ever have happened about 10 or 15 years ago, that there would be such a recognition of the role of women in the legal profession. So in conclusion, may I welcome you today to the CLE's sequel to Women in the Legal Profession Part 1. The speakers you will be hearing from today have been carefully selected because of their expertise in the areas that they will be speaking on, and I know you'll find most of them, in fact, all of them, I hope, to be exciting and stimulating. So remember, though, that no matter what anybody tells you, equality is not when a female J.J. Robinette gets promoted to associate partner. In my view, equality is when a mediocre female lawyer gets promoted as quickly as a mediocre male lawyer. Thank you very much. Oops, I stole the microphone already.
Our first speaker this afternoon, after our charming and gracious introduction and welcome, goodbye, Denise, is Professor Lorraine Weinrib. We are very grateful to have Professor Weinrib here this afternoon. She was called to the Bar of Ontario in 1975 and was appointed to the Faculty of Law and the Department of Political Science at the University of Toronto in 1988 as an associate professor. Previously, she served as Crown Law Officer in the Constitutional Law Division of the Ministry of the Attorney General, and if she'd stuck it out, she would have been moving into the Clara Brett Martin building next week. There she specialized in constitutional litigation. In 1987, Professor Weinrib was appointed Deputy Director of the Constitutional Law and Policy Division. Her counsel work included numerous appearances before the Supreme Court of Canada in a wide variety of constitutional cases. Her teaching includes courses on Canadian federalism, the Charter, and constitutional litigation. Her writing has focused on the institutional coherence of the Charter, the Supreme Court of Canada's Charter jurisprudence, and on particular cases, for example, the Morgentaler decision. Lorraine will be speaking to us this afternoon about perspectives on gender in the profession.
Thank you very much, Diana. It's one of those ironies of life that now, after I've been at the University of Toronto for a year, I hear that what I gave up was the opportunity to work in the Clara Brett Martin building. Let me begin my talk on perspectives on gender in the legal profession by telling you a story. It's an old story, and it's a story about two men, which may seem to be an inappropriate kind of story for a talk such as this, in a program such as this, but bear with me. 100 years ago, perhaps a bit more, in Russia, a country cousin comes to visit a city cousin. His plan is to stay for a month, but after about 2 weeks, he announces that he's going to cut short his visit. The country cousin says to the city cousin, "I just want to go home." The city cousin protests. "But you've just arrived. You haven't met all my friends. You haven't seen everything. You haven't done everything that there is to do." The country cousin says, "How can I explain to you how I feel? Where I live, I can get out of my house in the morning at dawn, hitch my horse to the wagon, drive all day long as hard as I can to sunset, sleep, get up the next day at dawn, do the same thing, drive all day as hard as I can, and still be on my own property." The city cousin says, "Oh, I know exactly what you mean. I used to have a horse and wagon like that too." Much of what I want to say about gender is the argument that gender has almost nothing to do in the legal profession with biology. That gender is a matter of the way we perceive things. And many of the problems that women are experiencing in the legal profession are problems of the culture of gender and not the biology of gender. In 1938, Virginia Woolf looked at the clouds of impending war in Europe, the possibility of destruction of the moral order as she understood it, and the probability of horrendous loss of human life. And she suggested as a solution that women should be admitted to professions in England. She thought that if women were included in professions such as medicine and law, through the education they would acquire, the power they would acquire, large salaries, through what she called their independent and disinterested influence, they could work for peace and achieve peace in the world. In the past 20 years, we have seen the legal profession open its doors to women in unprecedented numbers. 20% of the profession are now women. About 50% of the people in law school are women. The external doors of the profession have been opened. But what Virginia Woolf did not see and did not understand was that opening the external doors does not remove the entire problem. That exclusion can take place within the mansion of the legal profession by the narrowing of opportunities for women and by the devaluation of the work, the personality, and the life interests of women. Because women now form about 20% of the profession, they compose a critical mass. And the very topic of this conference this afternoon indicates that because of that critical mass, because of the numbers, women are no longer merely an irritant, as I felt I was when I entered the profession, and not merely a curiosity, but that women now have the power to transform the profession into our own image or into a new image altogether. I think that it's important to think of the legal profession as being transformed by the influx of women, because the problem that women faced with the exclusion of women altogether, and now with the closing of doors internally, is a problem that arises because the profession, not surprisingly, has been constructed in the male image and must change now, not only because that is an inappropriate way for a profession to run in general, but also because in the world we live in, it is illegal. What then is the problem? The perception of the problem, I think, like the perception of the city cousin hearing the country cousin's complaint, is not taking in everything that is important. One of the perceived problems is that women are not picking up the prizes in the profession, the jobs in the elite law firms that bring high salaries, beautiful surroundings, prestige, lots of support staff, the latest equipment. They choose instead what are called alternate careers. When I was a government lawyer, I was often asked to speak to law students about my alternate career as a litigator in the Supreme Court of Canada of constitutional cases. I couldn't quite figure out what the mainstream was. But these alternate careers involve finding women in disproportionate numbers as compared to men in government, in public service, in policy roles, in public interest advocacy, pressure groups of one sort or another. Some of this, I will concede, is because other opportunities have not been available. But I think that women choose, to a large extent, to work in these areas because they just simply do not value the prizes that men value, and they self-select in different ways, that they're not driven by the characteristics of the large firm and all it offers. So that in some ways, finding women in other places is very positive. On the other hand, to the extent that we find women in those careers because they felt they had fewer choices, this must be changed. And to the extent we're not finding men in these careers, these alternate careers, because they feel that they don't have choices, this must be changed too. Let me speak for a moment about what I call the male model of the legal profession that produces the position in the elite law firm as the highest prize. What we are seeing increasingly now is that the firms are looking not only for the best and the brightest, but for the people who manifest an unbroken commitment to the firm, starting now, earlier and earlier, after the first or perhaps the second year of law school, very long hours, the ability to attract clients, and the commitment to the professional component of one's life, to the extent that there are very few other interests that one can maintain and hold seriously. There has been writing in the sociology of business organization that indicates that when the work that people do is difficult to evaluate because it is a complex task, because the work is attenuated, abstract, or highly specialized, if the work is done for clients who themselves are a large organization, diffuse, and not as familiar with the valuation of the work structure, which I think is what we see in most highly technical areas of law. When that is the kind of work that's done, and those are the kind of clients for whom the work is done, then the valuation of the work becomes a valuation of style rather than content. And that style is a homogeneous style, by which I mean that it is difficult for people who are not middle-class men, who are white, educated in a certain way, to fall into that style. The style can be described as aggressive, confident, totally committed, a person who is easy in contact with clients, displays good breeding, good clothing style, confident and authoritative manners of speech, a person who evinces trust, a person also who evinces familiarity with sports and politics, a person who displays sexual and athletic stamina and energy and accomplishment. This list of things is the model of success in the legal profession, and it is very difficult for many women to meet that standard. That was the problem when I came into the profession in the early to mid-70s. Let me quote to you something that I think is a good example of this phenomenon. This is a quote from a person named Joan Harris, a successful American lawyer, a woman who prosecuted for part of her career. In describing her career, she said, "I am 5 feet 11 inches tall and have a low-pitched voice which when projected can break a brick at 50 yards. Of all the qualities born and bred which have contributed to whatever success the law has brought to me in the courtroom and in the office, I credit my height and my voice as the 2 most valuable factors." For someone who went into law when I did, that rings very, very true. Now, just as women had trouble conforming to that model of what is a successful lawyer, generally speaking, when there were very few of us, now that there are more of us, you would think that it would be easier, and indeed it is easier. I think that although when I began law, I was always conscious of my gender. In the last few years when I was practicing, I had a management position in the government. I had juniors who were male. I was not conscious at all, very often at all, that I was a woman. But when women become pregnant and when women become the mothers of very, very young children, that model, the long hours, the physical appearance even, and the savoir-faire of looking and acting like a lawyer becomes more and more difficult. I remember one of the most embarrassing moments that I had in my career when I stood up in the Supreme Court of Canada, and Mr. Justice Martland looked down at me and said, "Well, Mr. Weinrib, let's hear from Ontario," which was bad enough, you think, except that I was 8 months pregnant. And of course, all the lawyers in the room knew that, and there was sort of hysteria in laughing and trying not to laugh throughout the courtroom. But you can imagine how I felt. I mean, those kind of experiences are really belittling and degrading, and they have to do with assumptions about who lawyers are. So the proxies for merit in the legal profession are proxies that are difficult for women to satisfy when pregnant and when bearing children, and perhaps in the first months when children are very young. But we all know, if we think about it, that women don't stay pregnant for all that long, professional women don't have that many children, and labor, thank goodness, is a very, very short experience. Why then is there such a problem? There is a problem, I think, because the problem isn't a problem of biology, the problem is a problem of stereotypes. And the stereotypes are stereotypes that both men and women fall prey to. From the firm's point of view, a woman who may already have worked and worked very hard and very well for 10 years has suddenly demonstrated that she doesn't want to be a lawyer at all. That's what was said to me when I first became pregnant. The lawyer I was working with said, "But I thought you wanted to be a lawyer." But, what did the but mean? So that for the firm, it's very hard to deal, at least the first or second time around, with women who go on maternity leave. And who come back, or who may come back early, may come back late, or may come back and decide that they don't want to work the hard, long hours that they were working before. So from the firm's point of view, both socially and to a certain extent economically, there is a problem. But more to the point, I think, there are problems in the woman's own world, from the woman's point of view and from the point of view of her spouse and her immediate family. For the woman may be working not from the perspective of the law firm and the idea of the stereotype of the good and successful lawyer. The woman may be co-opted into an idea of ideal motherhood, which is just as vexing and just as incorrect, I would suggest, as this problem of what the ideal lawyer is. The ideology of motherhood is very similar to the ideology of lawyering in that it's very difficult to actually evaluate merit. So what we have again are proxies for merit. Proxies like full-time, hands-on, face-to-face contact with the child, poor child, And the illusion that one should be everything to the individual child. Again, we have a lot of style content here. We have a lot of style here rather than content. We have a style of how children should be brought up when they are lawyers' children. The kind of activities they should have, the kind of clothing they should have, the kind of preschool friendships and group activities they should have. And a lot of this is something that requires full-time mothering at home. And for any woman who has bought into both of those stereotypes, life becomes hell on wheels. This ideology of motherhood, if I could just pause for a moment on it, is a relatively new ideology, and let us hope that it is short-lived. It derives from the economic prosperity after the Second World War, because as we all know, in the Industrial Revolution, men, women, and children worked hard and long hours. They were liberated from that tyranny by the idea of the family wage for a man, the idea that a man would be able to support a family with a large enough salary by his own work so that the woman could stay at home. So we had what the Victorians called the angel in the house and the idea of the male breadwinner. And from that, the television programs Father Knows Best and Leave It to Beaver, which is sort of, I suppose, in many ways, the archetypes that we grow up with. I'd like to say with some pride that my children find these television programs absolutely bizarre. The problem is that as long as men and women buy into both of these ideal stereotypes of lawyering and of motherhood, we really lead schizophrenic lives. And we have to stop this, because if we don't stop it, then women lawyers will bear a far too high a burden when they choose to have children and when they choose to go back to the workforce at full speed after they have children. One way to dissolve these stereotypes is to realize that even though we all have a variety of talents and initiative, we all have so many hours a day. And most people can't be in two places at once. The mummy track is the idea that women should be somehow disengaged from the high-speed, hierarchical, upscale progression of the legal workplace and put aside for a while on a second track. But let me warn you that that mummy track in New York City is 9 to 5, 5 days a week. That is simply not the answer. What then is the answer? Well, one of the things I think we have to realize is the great extent to which these gender problems have to do with stereotypes and ideals rather than with actual biology. And we have to go back to that division of labor, that idea of the male as the breadwinner and the woman as the angel in the house, and crack those stereotypes open. Unfortunately, as the Privy Council told us in the famous or infamous Persons case, by which women were held to be entitled to admission to the Senate of Canada, that custom, which we would call stereotype, that custom is one of the hardest things to change in society, that it's even harder to change than law. And we as lawyers, I'm sure, all know how difficult it is to change law. One of the things I hope in the specific recommendations that come out of a program such as this is that firms won't be 100% successful in drawing and retaining the best and the brightest women. Because I would hope that public service and policy making, public interest advocacy, academic life will continue to draw people who are idealistic, who are talented, and who are hardworking, whether they're men or they're women. What I hope for is that we can free ourselves of these stereotypes enough so that we can see new forms of lawyering and new forms of parenting, so that women are released from the tyranny of the idea of the superwoman and of the angel in the house. What then do we need to go to this wonderful end state? First of all, I think we need more information. Information like we see beginning to be developed in the Manitoba study in your materials. We have to have statistics. We have to have interviews. We have to have personal accounts of the experience of women, of the place of women in the profession. Not too long ago, 1983, I had a tremendously difficult battle to wage in the Ministry of the Attorney General in order to get a leave of absence to do a master's degree in law at Yale Law School. What I didn't understand at the time was that a lot of the difficulty that I was having had to do with an understanding of gender roles by my superiors. The task of securing that leave of absence would have been so much easier for me if I had been able to recognize the patterns of gender stereotyping. We all have to help each other, men and women, and we only understand those things if we have more information. And fortunately, there's been so much work done in the United States that the work that has to be done has been clearly charted. So the first thing is more information. The second thing we have to do is we have to engage in education once we have the information that tells us what's out there on the ground and what's wrong with it. We have to engage in legal education in the law schools to, first of all, rid the law schools of the vestiges of gender stereotyping, and second of all, to prepare women for their contacts, their first contacts with the legal profession. There's been a tremendous transformation in the gender roles and stereotyping and hierarchy in the classroom in the law schools since I graduated in 1973. And that's been one of the greatest gratifications of going back to the law school in the last year as a professor. But we still have problems, and we have to work out these problems in order to make the law school as comfortable an environment for women as it can be. We've come a long way, but there's still more work to be done. The first contact that most women get with the profession is in the recruitment process, and I'm very sad to say that there are still a lot of sexist remarks made in that recruitment process. There are still opportunities that are openly described as unavailable to women because they are women, and there is still a devaluation of women's experiences in the recruitment process. This has to end. I have some ideas about how it can be ended, but I think the law schools have a responsibility, and they have to work hand in hand with the Law Society in order to make sure that the legal profession, difficult to change as it is, abides by simple mandates like those contained in the Human Rights Code. We also need, by extension, professional education. We need the profession to understand the statistics, the experiences that women have had, just so that a lot of the gender stereotyping that takes place can be recognized and then can be labeled as undesirable and alleviated, removed. We also need judicial education, and the Manitoba study points out some of the problems. We have institutions for judicial education in Canada. We have to plug in some of the wonderful work that's been done in the United States to educate judges so that they will be hospitable to women in the courtroom as lawyers and women in the courtroom as litigants and as witnesses. We also, of course, need law reform. But we have a lot of law reform. We're just not moving on it. We have to make the laws that have been changed real. We have to put them into operation. But we also need new substantive law, not only in areas that affect women's lives, but we also need laws that provide adequate daycare, and we need laws that improve the pay and the conditions of work and benefits for people who work with children. We as lawyers and as female lawyers can't continue to devalue the best work that's done in raising our children. We also need policies initiated after study and promulgated by bar associations and law societies so that women who run into problems in gender in the world have someone to go to. There have to be recognized mechanisms for recourse when problems arise to implement those policies. There are all sorts of stories going around about sexual harassment, employment equity problems, equal opportunity problems, problems of exclusion and devaluation, in addition to these persistent derogatory remarks. There has to be something that one can do about this. Recently, a woman came into my office who finds herself in the position of having to leave a large downtown Toronto law firm. Why? because the senior partner to whom she was assigned can't work with women. Everybody in that law firm knows that he can't work with women, yet this arrangement was put together. The senior women in the law firm know that this is a problem, and yet there's nothing that can be done unless this woman risks her career by going to the Human Rights Commission. This doesn't seem right to me. There must be some other mechanisms of recourse. We also have to work closely with people who are experts in the larger world of the workplace in order to figure out how we can change the workplace to make it more hospitable for women. We have to have real maternity leaves, not maternity leaves where women take all their files home with them. I think one of the reasons that women don't come back successfully to the office is that they've never left. We have to solve these problems. We have to have flexible hours. We have to have the ability for women to work at home, which is easy with the technology that's available with us, for us today. And we also have to just recognize that reproduction is something that people do. Some people play violins, some people play squash, and some people have babies. All these things are priorities, and no one has their nose to the grindstone 24 hours a day, 7 days a week. You may think that this is a large agenda, but in fact, most of the work is done. You have to remember that in almost a 10-year period, we went from the Bliss case in the Supreme Court of Canada to the Morgentaler case. We went in 1979 from the Supreme Court of Canada's statement that a differentiation between pregnant people and non-pregnant people had nothing to do with the differentiation between men and women, to the Morgentaler judgment in 1988, where the monster of Section 251, the abortion section of the Criminal Code, was struck down by 4 judges in the Supreme Court of Canada, not even addressing the gender problem. And we also had the magnificent judgment of Madam Justice Wilson setting out that women have a liberty interest to abortion, but also in a very poignant part of the judgment, suggesting that if society is serious about babies and fetuses, wouldn't we see that in the way society reacts to miscarriage? Justice Wilson was able to create her, as it has been called in the literature, pro-choice manifesto, her well-reasoned and articulate judgment, if I can put it that way, without reference to the equality section, Section 15 of the Charter, and without reference to the special section in the Charter that guarantees all the rights in the Charter equally to men and women. We also have in place, of course, very strong human rights protections. The significance of these changes is that in terms of the macro structure around us, the law has already done a lot of the work that we have to do. We just have to make the legal profession conform to it. My suggestion there is that therefore is that we abandon the idea of a superwoman and of a superfather and move into a world where all people are responsible for reproduction and for children. And at 20% of the profession, we're in a very good position to get this project going. And once we clean up the legal profession and make it a hospitable place for all people with all kinds of interests, then perhaps we can move on to Virginia Woolf's agenda of peace in the world, or pursue other dreams of our own. Thank you.
Is Dr. Goring here?
Oh, no, you didn't.
I wasn't. I was going to do it myself. I just make it up. Dr. Paula Goring is an experienced clinician, educator, and researcher. Since joining the Clark Institute of Psychiatry in 1979, her research interests and activities have included a major study on the delivery of child aftercare services to discharged psychiatric patients and an investigation of depression in married women, as well as a needs assessment of homeless women. Dr. Goring has published articles in a wide variety of professional journals and frequently presents scientific papers at international meetings. Dr. Goring has recently had major responsibility for the establishment of a new division of continuing care at the Clark Institute, which is developing and studying innovative treatment strategies for patients with prolonged disorders. Dr. Goring is currently the Associate Director of Research for that division, is the Associate Director for Research at the Clark Institute of Psychiatry, is an Assistant Professor at the Department of Psychiatry and Faculty of Nursing at the University of Toronto, and as well maintains a psychotherapy practice. Dr. Goring will be speaking to us today about work, women, and stress.
Good afternoon. I need these lights out because I'm going to use slides and you can't see them. Can you turn those? Thanks. And I need to find the... There we go. When Dory Cameron saw me today, she said that she was looking forward to hearing what I had to say this afternoon because she'd had a particularly stressful morning, having left the house with a crying child. And I want to reassure her and all of you that it is possible with few minor sacrifices to have a stress-free life as a career woman and as a mother. Let me just give you an idea what those sacrifices may be like. Here. Can we have more lights out? Can you not see? It's important that you see the slides because it's better for them to see the slides than me. Yeah, they're here today. We don't know who's going to watch the video.
Everybody moves down. We can see it from here. Maybe just people who are far back.
There we go. Is that better?
Could you do the ones at the back?
No.
Quite a lot of daylight coming into the room. Thank you. More.
I can't go any farther unless I turn off my room.
Okay, let's try this. And if you can't see, you might want to move down a little bit because I think it's okay now in front? Yes. Good. And am I in your way? Okay, now we can go. I'm going to talk today about stress, and stress in particular with regard to professional women, and also specifically focused as much as I can about women lawyers. Let's start out by just reviewing a little bit about the underlying conceptual framework that we use when we do studies of occupational stress. It's important to keep in mind that what we're talking about here is in response to environmental stressors. There are things that happen out there, which we call stressors, which would create a response that is filtered through your own personal way of looking at things, of appreciating things and understanding things. And that the result of all this is the stress response, which always includes a certain level of arousal and then various methods and efforts that you use to try to cope with that arousal. Now, there are lots of different things that can happen when you get under stress, including exhaustion, tension buildup, also coping and direct response to the stress, or relaxation, release, and turning things off or turning things down. People who are under stress for long periods of time have a higher incidence of physical, emotional, mental illness. There have been numerous studies which over and over again with various kinds of measures of health-seeking behavior and symptoms and illness have shown that we have a clear connection between the amount of stress that you're under and the likelihood, the increased likelihood that you will be ill, or emotionally and physically. It's also clear that you're less effective when you're under stress for long periods of times, and that organizations where there's a large degree of stress are not as productive or as comfortable environments in which to live. So although we all live with stress all the time, too much of it for too long is clearly unhealthy. Now, I'm not going to go into all the research evidence for a lot of the things I'm saying today. I've given you a fairly long reference list, and if you're interested in some of the methodology and statistics, you can go to those articles that are cited. I'm going to summarize for you today. The question of whether or not women lawyers are under more stress than people in other occupations is one we don't really have an answer to. There have not been very many good studies about occupational stress in women professionals, much well women lawyers. The review that I've cited by Ha shows that for every 6 studies that have been done on men with regard to occupational stress, we have 1 study done on women. There's a great imbalance in that research and in that literature and in the attention that's been paid. And the research that's been done about women and occupational stress has been very narrowly focused on one question. And that question basically was, should women work? The underlying question was, are women, housewives, better off than career women? And there are 10,000 different ways of approaching this. So there's very little bit available about when women do work, what happens, what kinds of symptoms, how do they cope, so on and so forth. There have been a few surveys that have been done about women lawyers in this issue, and Cynthia Fuchs-Epstein is probably the person who writes the most in this area. She takes a particular perspective, which is that women lawyers are not stressed, and that you do yourself a disservice when you think of it in this way. She talks with successful women lawyers who say that they're under pressure, but do not acknowledge stress, and also do not acknowledge a great deal, much of discrimination. But when I read through that work, I wonder about the representativeness of the sample, and I wonder too about the particular, you can look at it yourself, but it looks like there's a particular bias that's going, or a political agenda that's going into some of the way in which the questions are phrased. I really can't tell you, and I don't think anyone knows, whether women lawyers in comparison to women doctors in comparison to other female professions have higher levels of stress or less. You may be able to answer that question a lot better than the research can anyway, just by looking at your own lives. But it is fairly clear about what the major potential sources of stress for women lawyers would be, and they're listed here. Being of minority status, or being in a position where you're the recipient of gender discrimination, is in and of itself stressful. Type A behavior is a particular personality style, a particular kind of filtering that goes on in that box called the self, which increases the likelihood of stress, and which I'll argue today is something that you need to be very aware of as women in the legal profession. And the major stressor found over and over again across professions when women are interviewed is job-home interaction, as it's called in the jargon. That's what Dory was talking about, leaving home crying child this morning. I spent the morning in the hospital with my mother trying to get her broken ankle taken care of, those kinds of issues. I'm not going to talk a lot about discrimination today, because I think it's going to be well discussed and it's well documented in your literature. I put in this cartoon because I think that the discrimination you face may be very subtle at times, and unless you're an insider and know the joke, or know the secrets or know the clues, you may not get it. Nobody gets this cartoon, obviously. Oh, you can't read it? He says, look, I'm sorry. If you weighed 500 pounds, we'd certainly accommodate you. But it's simply a fact that a 400-pound gorilla does not sleep anywhere he wants to. Some people know the joke. Discrimination is, and the kind of toll it can take, are illustrated really well if you think about the commonly identified stressors in the work environment, which are listed here: heavy workload, time pressures and deadlines, long hours, role ambiguity, strained interpersonal relationships, limited opportunities, value conflicts, and job-home interaction. Now, those are there for men and women alike. We know these things make jobs more stressful. But if you are in a position where, by virtue of your gender or your sex, you are discriminated against, then many of these things will be exacerbated or amplified. If you read Cantor's work on the sociology of women in the legal profession and her description of tokenism, you see how women lawyers may be put into a position where they work even harder or feel compelled to work even harder, and where there's oftentimes this undercurrent of conflict and strain because of the kinds of things that, as were mentioned in the earlier presentation, of a slight difference in the rules and the dress and the code. So there are a number of ways in which just the work environment itself is changed if you are being discriminated against. Now, if you look at the surveys of women lawyers, not the kind of material that's documented today, but the few surveys that have been done, there is a great deal of variability in whether women acknowledge that they are ever discriminated against, or this is a barrier or an obstacle for them. For me, it gives the lady justice with blindfolds on new meaning, because the evidence seems to me to be very strong. But if you go to people's personal spaces and their own views of the world, there are a fair number of women who would say this is not their experience and that it's not what happens to them. I think we need to keep that in mind. It is possible that there are some reasons to argue that being a women lawyer is not all that stressful. Let me just give you some examples. One of the kinds of personality factors that has been identified in the literature as being important in being able to withstand stress and not get ill is something called hardiness. And it's a personality trait. The researcher that's done most of the work in this area is named Kobasa. And the personality trait talks about people who have a sense of commitment, who see things as being challenging, and who tend to feel that they're in control, that they can have an impact. If you have that constellation of sort of way of viewing the world and viewing yourself, you are hardy and less vulnerable to stress. Well, those kinds of things may be the kinds of things that also would be self-selective for women going into the legal profession, wouldn't they? The other thing to think about is that we know that one of the things that counterbalances the stresses in a work situation are the kinds of rewards and resources that people get from being in a profession. And again, if we recognize that a fit between your particular abilities and what is being demanded of you is a part of what contributes to job satisfaction and reduces stress, then having choice and doing what you want to do and feeling challenged and getting the financial and status rewards that go with that are all things that would say that women lawyers may not be so stressed. We've done numerous studies in the social and community psychiatry section, of which I'm a member, looking at occupational stress. We haven't looked at women lawyers, but in the studies that we've done where we've looked at entire organizations across different rankings, we found women clerical workers to be the women that were the most dissatisfied, the most distressed, the most depressed. And I think it's important to keep that in mind. But there also are ways in which personality styles and the self-selection process may get people into a position where they are under a great deal of stress and unwilling to either see it or acknowledge it. That's the flip side of it in terms of possibilities about why we find such variability and whether or not this is acknowledged to be a part of the profession. One of those personality styles, which has been important, is the type A personality. This is a gentleman, and I couldn't find any slides that had women in them. They aren't out yet, but they will be, who comes in and says, "Nobody came to work today, Mr. Farvis, because today is a national holiday. Today is Christmas." This was a lot funnier before I did this one day. I went into work and found it was a holiday and I was the only one there. It wasn't Christmas, but it was. Type A behavior and a particular constellation of traits, which is defined this way: a hard-driving, aggressive, competitive, rush style of life, which is associated with a substantially increased risk of coronary heart disease. That has been shown over and over again, that this particular constellation of traits increases people's incidence of heart disease. And until recently, this has been seen as primarily a problem for male executives. There have been several recent studies, though, which have shown an increase in type A behavior and in cardiac heart disease in professional women. And the studies show that there's a very similar kind of physiological thing going on in the women with increased blood pressure and a higher arousal rate in general, that it's associated with the high status and working more hours than one prefers. Type A against the grain is even more pathological or risky than type A that seems to be chosen and to be selected and to be what you want to do. There are lots of different ideas about why this might be developing in women, but the most obvious seems to be the getting ourselves into the situations that, and the work situations where demand this. This is old data. I'm sure it's changed dramatically. I just couldn't find anything more recent when I did this lit review, which looked at the number of women working 41 or more hours per week and showed that lawyers and judges were second only to physicians among women who were gotten themselves into this work pattern. And these kinds of behaviors, I'm sure you recognize either in yourself or in your colleagues. I try to be on time for all appointments, and how often or sometimes is the right-hand column. I find it hard to find time for personal errands. I'm faced with irritating and frustrating situations. I eat rapidly, finish meals before other people. I give everything I have to my work. I find myself doing several things at one time. I get impatient when someone's taking too long. I'm very ambitious. I tend to keep feelings to myself. If you have a lot of yeses to those questions, then you need to think about what it means in terms of your psychological and your physical health. And the question, which is the same for males in terms of at what price is success in terms of one's health, becomes very relevant. Now, the long hours also have implications for that third factor about job-home interaction. This is Kathy, whom I love, who says, "Oh, Irving, I've been so busy at work. Me too. I'm just exhausted. Me too. But we're together now, Kathy, and we can relax and enjoy each other." We're both asleep. Is it recognizable? Because obviously for women with type A and the long hours, we still have the distinction that when they go home, the work isn't done. And it's not just one job, but it's two jobs, and we are a long way from having an equal distribution of responsibility for the home and for child care. And this is the big one. This is the one that comes at the top of the list when you ask women lawyers what it is that's stressful in their lives. The hardest thing, balancing a job and family is not the hardest thing to achieve. It's the second after world peace. This necessity of thinking about job-home interaction is relatively new. A lot of the studies that were originally done about women in top managerial positions were done of women who chose a career over family. And it's only recently that we've had the phenomena of large numbers of women's professionals who also are raising children and being married and attempting to balance one. This is a fairly large survey that was done in the States, which showed that of all the women surveyed, 85% were married and 40% had children, and 17% perceived family responsibilities and conflicts as major weaknesses that had interfered with their ability to progress in their professional careers. Well, that's 1 out of 5. 49% had been taken a maternity leave of less than 2 months in that population. You're not going to be able to read this, so I'm going to tell you about it. The research that I told you about earlier about women and occupational stress that started out saying, well, is it a homemaker better off than a professional, came up with not any clear answers to that question. Generally, career women on most indices of mental health had a little bit of an edge and were doing even better, which wasn't what was expected when a lot of that research was started. But there weren't clear and definitive answers. The next series of studies looked at the question of whether people who had more than one role, it was called multiple role obligations in sociological terminology, were less healthy and more likely to be ill than people who had one role. And that was called the additive model, that tried to just not define what the role was, but how many you had. Even there, the research was fairly inconclusive about what effects it had to have multiple roles on your mental health. And it's only recently that the social scientists have come to looking at the situation and what seems to be common sense, but it always happens this way as it comes later, where the kind of thing that's looked at is the quality of whatever role you're doing and the balance of what rewards you get from it and what risk you take or what disadvantages it entails. When you do that, when you start trying to get at what the nature of the parenting is like, what the nature of the marriage is like, what the nature of the job is like, then you can obviously show some fairly clear connections between the job and home and marriage and health. So that Barrick and Barnett, who've done some of the best research in this area, have shown that women perceive the rewards of being a wife as having someone who backs you up in what you want to do, companionship, having someone sees you as special. But the concerns and the flip side have to do with whether the husband has physical health problems, whether you fight over the children, whether the husband has job problems. These were things that came to the top of the list as being important determinants of the mental health and emotional health of the woman who was married. You can do the same with being a mother. Getting love from your children, liking the kind of people they are, having pleasure in their accomplishment were important things which were positive and had positive effects on women who are mothers. Worry about their physical well-being, worry about teenage years, financial strains were the flip side of that. So that for any woman or any group of women, you need to know more about the balance of those things before you could answer the question. It is quite clear, though, that the hardest time for all women is during the preschool age. Or I can't say all women, but for most women. The most stressful time in this balancing of work and home is when you have children who are preschool age. These are some of the stresses which were identified in one study, trying to do it all well. That's the superwoman complex, not having any time, not spending enough time with the children, finding good child care, caring for sick children. Notice how often physical illness enters into the picture in terms of that caregiving and caretaking role that's usually assigned to the woman in the family, and then increases the responsibility and increases the stress. These same group of women who identified as those stressors also talked about what helped, and a good support network was at the top with good sitters coming out above supportive husbands. An extended family coming next. Organizing and managing their times and using physical activity as stress management were things that were found helpful and were correlated with women who were doing better in this stressful situation in this one study. I have to read this again. I think you can't read it. This is about coping. Kathy says, you went out and got drunk because you were jealous? That was stupid. How is that any more stupid than you eating when you're jealous? Irving, I eat when I'm depressed. I buy shoes when I'm jealous. I break the telephone when I'm angry. I mangle my fingernails when I'm lonely. I throw things all over the house when I'm hurt, and I waste money on makeup when I'm frustrated. Men just don't know how to cope. coping is a fairly individual thing. We all find different ways of trying to manage the stress that comes from the three factors that I've mentioned. But there also are general things that we know that, on the whole, are not helpful. When you're in a stressful situation and you're trying to manage a great deal of anxiety, depression, insomnia, so on and so forth, these are typically dysfunctional coping styles. To withdraw, to feel helpless, to keep it all inside, that's what internalization really means. To have emotional outbursts and then a lot of repression. Some people do that. They keep it all inside until they can't any longer, and then it explodes, and then they feel terrible and guilty, and they put the lid back on and go on for a while. And being over-controlling. Now, can you see some of the type A personality stuff there? And maybe some things that might be self-selective for becoming a woman lawyer. I'm not sure about that. But some of these things, which in some contexts may be constructive, may, with regard to our own physical and emotional health, not be so constructive when we're being very controlling and keeping the lid on and not acknowledging what's going on or sharing it. Typically, support seeking, using diversion and tension release, and direct action are the most constructive things that you can do to manage stress. So these are the things that either do something about the situation, the direct action and the support seeking, or help you manage those unpleasant feelings that you're having in response to the situation in a constructive way. With diversion and tension release being very important. And that's where the physical exercise and the finding time for recreation and relaxation makes so much sense. It makes a lot of sense. It's not always easy to do, as this lady shows. Can you read that one okay? Yeah. She doesn't, every day, no matter how busy you are, you should set aside some time to relax and unwind. Time's up. She doesn't have preschoolers, but it doesn't stop. Preschoolers get to school, for certain. Still, there's something very important to attend to about the need for reasonably healthy lives in terms of nutrition, in terms of relaxation, in terms of physical exercise. And those are the things that can go by the wayside when you're trying to manage the career and the home and trying to do it all incredibly well. In the long run, what can suffer is your health and thus your own capacity and resourcefulness and resiliency so that you can do those other things well. But this piece of it, this personal piece of it, is sometimes the hardest to keep your attending to, and the one where it's very important that you have support. Well, people get support from various places. That, again, there's a whole body of research now about social support. But really, basically, what we're talking about here is things that you get from coworkers, from professionals, family, friends, and from your family that fall under I'm stuck, but I'm almost finished. It's okay. I don't need this last two. No, the records. No. Don't worry about it. It doesn't matter. The next slide had some examples on it of getting support and what's involved in that. It can be something as simple as just having somebody to ventilate to and to talk about what's going on. It also can mean having somebody who goes to fitness class with you or to whom you discuss going to fitness class with, if that's necessary. There are lots of sort of emotional and instrumental things that we can do to help each other. But this part about providing support is also a part that's very important to keep in mind, that organizational piece. Because the organizations and environments that we work in can also be supportive or not supportive. of living reasonably healthy lifestyles. And hopefully today you're going to hear about some examples of alternative work environments where people are experimenting with other ways of organizing the work environment so that it makes it easier to not work so many hours, to have more time for oneself, and to reduce the degree to which stress is seen as an inevitable part of one's life that is really unmanageable and just has to be taken as a given. Thank you.
Thank you very much, Dr. Goring. Our next speaker is Lynne Sullivan. She is a principal with William M. Mercer Limited and is a recognized national authority in equality issues. Ms. Sullivan is leader of the Mercer Human Rights and Employment Equity Consulting practice in Toronto. Among her impressive record of consulting assignments are working as the project manager for comprehensive audits of equal opportunity status at Petro-Canada, Gulf Canada, Suncor, Everready, and the regional municipality of Durham. Development and delivery of equal opportunity training programs for employees, managers, and human resources officials of large public and private sector organizations. Development of a casebook on employment equity for the federal government and conduct of a study on marketing employment equity for the Ontario Women's Directorate, and again for the Ontario Women's Directorate, a project manager for pay equity studies. Ms. Sullivan was a founding member of the Charter of Rights Educational Fund and was instrumental in establishing the Legal Education and Action Fund. She co-authored a chapter on age discrimination for a recent Carswell publication, Equality Rights in the Canadian Charter of Rights and Freedoms, and she is the editor of Equal Times, a business newsletter on equality issues published by Bedford House Communications.
Whoops. Not very good getting mic on though. There, is that okay?
Can you hear her?
Okay, well thank you all for coming this afternoon. I'd like to acknowledge the interest of the Law Society in putting on today's seminar, which is on a topic that business has been very interested in and has had a requirement to be interested in for a number of years. I've been asked to talk about other developments or developments in other areas, which I took to be the general developments in providing a more adaptive workplace and what are called alternative work arrangements. I'm going to talk about the alternative work arrangements that are available, why they're available in a broader context than just law, because to be quite honest, I think that one of the challenges facing professions like your own is to continue to be an attractive employer of women. And to the extent that other professions or firms other than your own become more attractive employers of women, women will be more drawn to other professions or to other firms. I speak as not only someone who consults in issues that are relevant to today's topic, but also as a representative of a firm which is a large employer of what I guess you call lawyers in alternative careers or alternate careers. We probably have 30 or 35 lawyers at First Canadian Place, which means we employ a lot more than a lot of law firms, and we employ lawyers in other other of our 18 offices in Canada. And lawyers in our company can enjoy careers which include membership on the board of directors and indeed a membership of the board of directors of our parent company, which is a very large international firm. So there was an advertisement for law at Mercer's. I also have to tell you that if my president, Dan McCaw, was here, he would tell you that we have benefited over the years by the employment practices of law firms. And we're no prize. And we ain't great, let me tell you. We just, I'm a principal, there are 5 women principals with Mercer's, and there's a lot more in Canada, and there's a lot more men, and we just got our first women office head. Although in our firm, being an office head is like something you have to do for a few years. When you return to sanity, you're allowed to return to consulting. But if Dan McCaw, our president, were here, he would tell you that over the years, we've been able to attract a large number of women lawyers. And we employ mainly tax lawyers. And the reason we were able to attract them was because they did not get offers from the places that they articled. And in one case, a woman who's now an officer of our company was told by the partner in charge of one of the large downtown law firms that she was the best articling student they ever had, and she would not get a job offer because she was a woman and they did not hire women. And she's been with us a few years now, and I think they've probably changed, but I've looked at their numbers and they still don't hire very many women. So we've benefited initially in hiring, and more recently we've started to attract women, including some who are partners at large law firms. And the reason that they came to us was because they felt that they could work part-time, genuinely work part-time, that is, come in 3 or 4 days a week and not spend the other day answering the telephone or having a fax at home. So it's been to our benefit that you've been a little slower to adapt, and it's actually against my best interest to be here today. However, I'm not sure that they're always right in coming to us, and I think we're as bad as everybody else in making extreme demands on people. Our women lawyers pioneered part-time working at our firm, and now we have part-time manager of pension administration and part-time computer systems consultants and so on. But it was the women in law who pioneered that, and the firm had to have them pioneered that because we needed them. And we couldn't, it takes us years to train pension lawyers, and their clients, as your clients, have extremely close identification with their consultant. And if we were not bringing back their consultants, we would be in very deep trouble. So I hope that we'll be able to continue to do that. Why isn't that going on? Now this went on just a minute ago when we tested it beforehand, so I'm not sure what just happened. Yep. Thank you. I was glad to see Dr. Goring use slides. I thought I might be at risk being the only person who used them. Consultants cannot talk without slides. And if I had a flip chart, it would be even better. Yeah. Oh, good. These are not as sexy as Dr. Goring's slide, however. Okay, I want to talk about a number of things that have to do with what are called alternative work arrangements, which I think of really the arrangements that we will find more of in the future because they reflect workplaces that are more adaptive to the labor force and the values of the society. I'm going to talk very briefly about the context because I do not believe that any successful organization can be very out of step with what is happening in competitor organizations or organizations that offer good opportunities. So I don't think that law can sort of hive itself off and be different, although I must admit that professions like engineering have hived themselves off in how they treat undergraduate women and continue to, and aren't yet ashamed of that either. Okay, so I'm going to talk about the context, a little bit about the status, in other words, where we are now in terms of alternate work arrangements and trends, the issues and opportunities for the employing organization and the individual, and finally, if your organization is looking at establishing alternative work arrangements, what kinds of things do you have to consider to make those arrangements a success? And this is going to be like a quick breeze through, and you're going to notice I'm going to be skipping parts. Now, there are numerous kinds of alternative work arrangements, and these are merely the most common kinds of alternative work arrangements. Flexible time and flexible year, which is the most common form of alternative work arrangements. Reduced work week, which is what I grew up thinking I was going to have in the leisure society of the 1980s. This never happened. It's what they talked about all through my teenage years. Job sharing, variable work hours, part-time working, casual work, labor pools, contracting out your part of what's done in your firm, contracting in people to work, employment contracts, and working at home, so-called homework. There are two main or generic kinds of ways of thinking about alternative work arrangements. They're either flexible or restructured full-time jobs, or working a reduced week or work time. Now, I said before that no organization, no competitive organization can afford to be out of step with what's happening elsewhere and why it's happening. And there is no doubt that a lot of the drive to have alternative work arrangements in the past has had to do with the influx of women into the paid labor force. And more importantly, as economists have the gall to call it, the influx of prime age married women. Prime age means 20 to 45 if you're economists. So we already knew that they had, deficiencies, but to call 45 the upper limit of prime age, I tell you. But it has lots to do with other things, and will continue to do. I think the prime factors that any organization has to keep in mind are what's happening in the economy, what's happening in the labor force, the employer's own objectives, values and public attitudes, which you have to respond to, the legal environment, which makes these things more complicated, perhaps not for your law partners, but certainly for other people you and your clients employ, and unions which don't affect you but certainly affect your clients. I think there's two prime things that will encourage alternative work arrangements in the future. One is the move to a global economy and the requirement to be more flexible and adaptive and also more competitive. And anything that requires competitiveness absolutely requires flexibility in your arrangements. And secondly, technology, or in other words, the technology now exists to have alternative work arrangements, and therefore there will be more of them. In terms of the labor force, we will just continue to be dealing with a labor force that's no longer your traditional leave it to beaver, we call it, family with two stay-at-home parents and children. It will be a labor force that's more highly educated and that involves more women in that paid labor force. Because while the labor force participation of men has been relatively constant over the years, the labor force participation of women has been increasing from 1961 through 1987. And in fact, at the present time, women constitute going on for 50% of the entire labor force, and 2 out of 3 women with children under 3 years of age, married women, are in the paid labor force. So I think that trend will continue and will require, therefore, any organization to consider women as seriously as they consider men, because simply they will just draw from such a small part of the labor force if they don't. And the second thing is the aging of the population. We have had a delightful young woman in our file room, by the way, who liked to draw, so I got her to do my slides instead of generating the usual computer ones that we have. But the aging of the population is probably the most significant labor force issue facing all organizations at the present time. And the concept that we currently have of retirement is going to go out the window because they're not going to be able to let us go. So if they don't treat you right now, remember that they are going to need your services in about 20 years or even less. Because whereas we currently have 6 persons in the paid labor force for every person of retirement age, by the year 2031, that ratio will be 3 to 1. By the year 2011, all baby boomers will be hitting retirement age. And we will be looking at longer lifespans with more flexible work arrangements through those lifespans and work arrangements that relate to your life cycle. Or in other words, many more people choosing to work less at certain times of their life, such as when they are when they have young families, or when they're going back to school, or when they're taking responsibility for family members who are ill or elderly. I think in addition that equality issues are strongly supported, and all research points to this, by Canadians in general, and so moves to, in fact, require employers to be more adaptive and flexible, if anything, will accelerate. And I think the proposals, for instance, which were announced last week, to extend the period in which unemployment insurance benefits are paid for maternity leave to a much longer period are indicative of that. Now, if we look at research on who wants to work less, it is not too surprising to find that the interest in reduced work hours, women are the slashed bar on here, is highest among women aged 25 to 34, and that women in general at all ages except the very young and oldest groups have a greater interest than men in working part-time, or fewer hours than they currently work. If you look at the reasons for that, men are green on here and women are yellow. Men are much more likely on the left-hand side to want to work fewer hours to pursue their leisure interests. You see, they've always said that women stay at home and work part-time so they can improve their tennis game. In fact, men are golfing or pursuing their hobbies. And on the right-hand side, women are more likely to want to work less time to take care of other responsibilities, such as caring for their children or maintaining the house so that it's fit for people to visit. Or in my case, I'd like to work part-time so I could pay my credit card bills. When Dr. Goring said the part about, compulsive behavior and not getting things done and so on, I have been carrying around for 3 weeks my Visa bill, my telephone bill, everything. I mean, it's terrible. I don't remember the last time I was in the bank, actually. Oh, it's not done. Nancy, don't even mention my income tax. I realized, I finally looked for my receipts the other day, and I have like a little Karen Magnuson competition skate box where I keep all these important documents. I'd love to be audited. And, no, I wouldn't. I'll take that back. And I think I'm missing a receipt from Leaf, actually, Nancy, if you'd like to do something about that. Okay. When we look at what alternative work arrangements are already available, this is data from a study by the Social Planning Council of Metropolitan Toronto. And what we will find out is the sexy things that people talk about are those that are least available. So if we start at the bottom, flexible work hours were available in 25% of responding employers, part-time work in about 20%, personal or family leave, which means being able to legitimately take days off for reason other than vacation or statutory holidays or being ill. So being able to call and phone in and say, listen, I'm taking a personal leave day, and that's when you take your kids to the dentist or go to the ballet recital or whatever. Maternity leave, meaning extended maternity leave beyond statutory entitlements, at 14.5%. 5.4% provided some form of paternity leave or leave for men surrounding the birth of their child. 5.7% provided job sharing. 4.5% opportunities to work at home, and 0.4% workplace daycare. That's the issue the press talks about. It's almost never available. In terms of interest indicated by employers in alternative work arrangements, again, flexible work time moved up from 25% who provided it to 26.4% who said that they were interested. Work-related daycare, 26% of employers said that they were interested in providing some services related to work-related daycare, but only a very small proportion, you'll remember 0.4% actually did provide it. Part-time work with prorated benefits was 25.3%, job sharing about the same, maternity and adoption leave about 22.6%, paid leave for family responsibilities 20%, paternity and adoption leave 16%, and 15% said that they were interested in looking at working at home. So what we've seen over a period of time is a move by employers to look at issues like assisting with daycare and providing various forms of leave surrounding family responsibilities. And the question is now, will they do it, and how will they do it? Well, I want to look at what's actually happening in some of these areas, and then what questions you have to look at in implementing them. First of all, it's extremely difficult to get good data on arrangements that are made because the survey research to get it would be very difficult. And a lot of the published data is small studies like this, well, not small, it was actually quite a big study, is local studies like the Social Planning Council, or studies that look at provisions of things like collective agreements, because it's very easy to get data on what collective agreements provide. If you look at who provides extended maternity leave already, collective agreements covering more than 1 million workers provide 5 months or more of maternity leave already in Canada. But you must appreciate that those include collective agreements which have many men in them as well. Only 25% of unionized employees are women. So there are all sorts of men out there who are entitled to extended maternity leave. When you get to maternity leave and extended maternity leave being provided to other employees, it's most often available to management and professional employees, and it's very often available on an ad hoc basis. In other words, there's no policy that says that if somebody wants extended maternity leave, they've got an entitlement to say, I know I get my 17 weeks, I'd like to have another 6. They could be easily turned down if there's no company policy in place. Monica Townsend, who many of you may know of as a financial writer, did a major study on a related issue, which is family responsibility leave. Family responsibility leave is the kind of leave you can take to attend to personal responsibilities such as ill children or other, taking care of a relative or errands you've got to run or that sort of thing. In Monica's study, she looked at the practices of the 35 largest employers in Canada and found that none of them had formal policies on that sort of leave, and that only 23% of collective agreements in Ontario provide such leave. One of the biggest ones is the General Motors collective agreement, and that, of course, covers very few women. I think about less than 10% probably of General Motors employees are women. So what this means is that existing policies to guarantee an employee the right to such leave are not in place, and that the arrangements that are in place are less formal. Again, this is part of Monica's study, which was for the Labour Canada. There's leave by right for family responsibilities, in other words, statutory leave, only in the federal public service and in Quebec. The federal public service model, however, is likely to become the model for legislation in Ontario and other provinces. In the federal jurisdiction, employees can take up to 5 days a year for family responsibility. They can take other forms of unpaid leave for personal needs, and male or female parents are entitled to take up to 5 years out of the federal public service for care of preschool-aged children, and are guaranteed the right to re-enter the public service. They also, however, are required when they return from the leave to pay back their pension contributions, which involves paying the employer's share and their own share as well as current contributions. So it's a huge whack, and therefore what happens is low-earning women can't afford to take it, and the women that do take it tend to be professional women, which is fine for those of you who pursue public sector careers. This type of model is quite likely, it is extending to other parts of the public service, and is likely in some parts of it, at least in the part that requires some form of personal leave as a statutory entitlement, to become entrenched in provincial employment standards legislation for your clients, if not for your firms. Daycare. In a 1984 study, which is the most recent one I could find, there were only 79 employer-sponsored daycare centers in Canada, covering 2.5% of licensed daycare spaces. What is becoming much more common, however, is various forms of information and counseling related to daycare and emergency daycare referral. There are lots of good reasons why employers don't have daycare centers, and they revolve around parents not really wanting to bring little ones into urban centers. For instance, who wants to take a toddler in the TTC in their little snowsuit in the morning? They involve the licensing, the cost, and various other things. So more common than employers actually having daycare centers is employers buying priority access for their employees to other daycare centers, such as those provided by local agencies or churches. There are 2 software packages that exist at the moment in Canada, which employers can buy into. They're not very expensive, and they help employees locate the type of daycare that they would like in their own area. There's also a package for finding help with elderly or sick relatives. So I think what is much more likely to become common is an obligation, at least an expected obligation for employers to help employees find daycare and to help them on an emergency referral basis when they've got a problem with a sick child. And also to subsidize daycare costs, which we find in our firm, of employees who have to travel overnight for their jobs. There's an awful lot of pressure, and it's becoming much more common to have to do that kind of thing. In terms of other alternatives, we don't have to talk about the statistics on part-time employment to know that most part-time workers are women, but what's happened in terms of part-time jobs is that part-time jobs are now available in a greater range of jobs. There's an assistant deputy minister in the Ontario government who works part-time. There's a vice president of a Schedule B bank in this city who works part-time. And part-time work is no longer uncommon in either managerial or professional ranks. In terms of your clients, there's also a lower threshold for who's considered a part-time employee. People who work 2 days a week are considered regular part-time employees, and those of your clients who have them have to now very shortly start including them in pension plans. So I think in terms of the trend to part-time working in law, there's a trend in general to having a much greater range of opportunities available for people to work on a part-time basis. So it's not just tellers and banks anymore, it's all kinds of professionals and even managers. Job sharing is also now available in a greater range of jobs. It is most often employee initiated. If you've got clients who are looking at job sharing, you will find that unions are exceedingly lukewarm to this issue and tend to put blockages in its way. Job sharing requires compatible job sharers. In other words, the most important thing about sharing one job as opposed to two people working part-time is the willingness of people to do it. And I was discussing just before this talk whether job sharing was a viable alternative in law firms, because I was thinking about it from the point of view of our own business. We employ part-time consultants. Our lawyers are consultants, and consulting is a business that we're in. We have never experimented with job sharing in this area. Job sharing, to my knowledge, has only been successful in non-unionized environments and in professions such as teaching and nursing. But thinking about it intellectually, I was thinking that in our business, job sharing might be more possible than in some other areas, because it would help you get over the client service problem that you sometimes have when you have part-time work. In other words, if there is some kind of a job sharing arrangement, the client at least has somebody to call into 5 days a week. Now, the gentleman who's going to talk later said that that's not his experience in their firm, and I'm not sure whether it might not depend on the field of law or the type of firm that you're in. But I think in consulting it may actually have some advantages over straight time, straight part-time. It would, however, require arrangements being made for people to deal with keeping up to date on the account, which I think is probably the problem, and with the service provider expectations. In other words, job sharing has proved not to work out in jobs where the public or the client expects to see a certain person when they walk in the door, such as your bank manager. It's entirely possible that in law that could be a problem if the client only expects to see one person when they come in to talk about a specific issue, rather than two. Work at home used to be what you thought of in piecework, people doing very isolated jobs at home. Working at home, and I noticed in the binder it talked about some of the law firms providing work at home opportunities, has become much more possible and much more prevalent with the advent of technology that allows it to happen. You can have obviously phones, fax machines, which are I was telling Dr. Goring, fax machines have created more stress on their own than anything. When the client calls, you can't say, oh, it's just gone in the courier. And then, my God, didn't the courier lose it? They say, oh, just fax it to me. It's a monster. It can be wonderful. I have fax proposals that I wrote on the plane on the way to the vacation, back from the parent company office when I landed. And my mother almost refused to take a trip to Italy with me one time. And I was providing the air tickets and everything. And I could see it in her eyes, And I said, it's okay, I won't do any work. I promise I won't do any work. Anyway, Homework is now much more possible because of technology. And homework, I saw from the binder, is happening in law firms. It's also happening in occupations such as computer systems or information systems for obvious reasons, not only at the clerical level, but also at the professional level. And I can see why it would have applications in your business. There are, however, significant problems with work at home, and I'm not sure what Dr. Goring would think about this, but my research says that the problems with work at home, although it has benefits, include isolation. In other words, one of the things we all get from work is social contact, affiliation, somebody to laugh at the joke, to commiserate with you, somebody to bounce an idea off. You lose that with work at home arrangements that aren't done properly. It provides a lack of work and family separation, and that's really very important. Most often people think of providing work at home when someone has very young children, little infants and toddlers. In fact, the most stressful time for a parent to be working at home is when they have those little people, because when the little baby or the toddler needs attention, the person who's working feels very guilty, and it creates stress problems. So the time when just sort of reacting to it intuitively, you would think it would have the greatest advantages. It has turned out to have disadvantages. For other kinds of work, there's also problems such as performance appraisal and supervision, which I think probably don't apply so much in law, but might apply if you have other people working at home in your law firms. Now, there's other forms of alternative arrangements that I won't discuss in detail, but one that would interest, I think, some people in legal profession is the formation by a number of firms of what I call labor pools, but which are, in fact, contracting in workforces. We often have thought of contracting in workforces as something you do with the cleaning staff or the security staff. But in fact, what a number of organizations now have is rosters of not only clerical and support personnel, but personnel who are professionals and managers who have an affiliation with them and will work for them. Those kind of arrangements are great for people for companies in startup and transition situations, and are now much more commonly used for professionals than they were before. They have difficulties for most individuals, such as protecting their income. In other words, you don't get long-term disability. But I wouldn't think that would be a problem for lawyers in law firms, because I think most of my friends in big law firms don't have that anyway. Now, in terms of some of the other things you're interested in, family responsibility leave, I think what we're going to be looking at, and what we're already starting to be looking at, is mandated extended leave available to either new parent. I think that's the direction of the unemployment insurance reforms, and that's the direction of proposed reforms in Ontario. It's also the direction of collective bargaining. In other words, it's an extension of maternity leave, what we now think of as maternity leave, to include a period of time when either parent can take time off to be at home with a newborn child. And I think what we're also looking at in terms of at least the legal environment in which you people will operate is requirements to provide family responsibility or personal leave on a mandatory basis. And when that hits all your clients, it's going to be pretty hard for it not to hit you. Now, people often talk about providing alternative work arrangements because they're of benefit to those individuals who have them. I would argue, and I think our clients would argue, that they provide great benefits for the organization. The greatest benefit of all alternative work arrangements is flexibility. In other words, they give organizations access to talent on a more flexible basis. They can staff up and they can staff down. They can deal with business cycles, and they can deal with pulling in the skills that they need at any period of time. They provide productivity benefits, which are documented. They may provide cost savings, although I would think that wouldn't be true in your type of environment. And some of our clients try and go into these to save money, and I always tell them that they shouldn't do it for that reason, because the benefits may be illusory. And they provide for better morale, or in other words, a more content workforce, because they're happier with the work arrangements that they have. Any organization that's contemplating implementing alternative work arrangements has to think about how to do it. And I'll be interested to hear about some of the practical experiences in law firms later. I just did up this little chart. Consultants deal in matrices all the time because it appeals to them somehow. And down the left-hand side, I've showed some of the more common forms of alternative work arrangements. And across the top, I've looked at some of the issues that any organization has to think about in implementing them. First of all, there are legal issues, if not for the partners in a law firm, then certainly for the employees and for your clients. In other words, there are some requirements around the basis on which you can have part-time employees, that you have to provide benefits for them, and so on. You have to consider how you're going to administer the arrangements and, in fact, your capacity to administer the arrangements. You have to think about, if you're having people where supervision is an issue, how you're going to supervise a function when people aren't there all of the usual same hours with the same work direction available, and so on. You have to think about the morale issues. Any organization that provides job sharing and provides it on the same basis as regular employment but treats part-time workers on an inferior basis is in for a morale problem. You have to think about training issues. Training issues are the #1 issue in communications for most employers who embark on anything other than traditional 9-to-5 kind of work arrangements, because you have to make sure that people are brought into training schemes and have the knowledge that they need to keep up to date with their jobs. Service delivery, those of you who, like myself, have had trouble with getting good service from major financial institutions in this province are experiencing the service delivery issues associated with alternative work arrangements. I did not get my mortgage with my own financial institution because I could not get anybody there at the hours that I went in, which did include the middle of the day, who could explain the products that they had available or how to invest my RRSP in my own mortgage. They did not think of having a phone there where I could pick up and get that information. And the reason that they have a problem is that they now service you in longer hours. The people who are there after hours or on Saturdays may very well be casual workers, may be a contracted-in workforce that worked last week for a different bank and this week is contracted to the bank or trust company you deal with. They therefore haven't kept up to date with the information and have very little loyalty to that particular organization. I think service delivery issues are major issues when you contemplate alternative work arrangements in a law firm, as they are for us in a consulting firm. We have to consider how we're going to service the client, what happens with the client when the client calls in on the day that lawyer or consultant is not there, and who do you refer the phone call to, when, if any time, does the person get called at home, and do you have a backup on the account, and all of those kind of things. Communications is another major issue. You have to have ways of making sure that people who aren't there at all of the regular hours and days are there when all the major meetings happen, which is a scheduling issue, are on your circulars for routing information around, and that at certain points in time the whole team is together, even if everybody isn't together 9 to 5, or in most law firms 6 in the morning till 11 at night, at all of the days. When Dr. Goring talked about the person coming in, the boss not knowing why people weren't there on Christmas Day, the worst story I know about workaholicism, is that the right word? Involves a friend of mine who's a partner in a large downtown law firm who got a phone call at home from a client at 7 o'clock on Christmas morning. And there was a witness. So I know it's true. And what I did was I went through the little matrix and I just put tick marks against what I think are all the main issues for whatever form of flexible work arrangements you're contemplating in your organization for your lawyers or for other employees of your firm. And I also left at the front an issue of a newsletter which talks about alternative work arrangements, talks about child care, and also talks about flexible benefits and goes through the highlights of what I've talked about. I think if you are going to look at implementing any form of alternative work arrangements, there's a number of things that you have to look at. First of all is clarifying your objectives, or what is it you're trying to achieve. Secondly is finding out what would be attractive. Too often employers make an assumption about what would be attractive. Well, women lawyers would like to work 3 days a week. Well, maybe what women lawyers would like is to work from 10 to 4. maybe men would also like to be among those who, get the choice. So I think any type of a survey doesn't have to be, professionally developed and validated survey, but some kind of a fact-finding initiative to find out what it is that people see as the issue and what would meet their needs. Don't assume that they want a daycare referral service without asking them about it, and so on. Assessing your capacity to administer whatever it is you're going to put in, evaluating your alternatives. Consider doing the more difficult things on a pilot basis to get them right. Planning for risks and contingencies, in other words, planning to meet the client needs when the prime lawyer isn't there, and generally adjusting your management practices to accommodate the kind of alternative work arrangements that you decide to implement. That's it.
Thank you very much, Lynne Sullivan. We're going to have a short break now. It was advertised as 15 minutes. Let's keep it down to 10 because I want to leave lots of time for what we have left on our program. Nancy Backhouse was called to the bar in 1979 and was an employee and then partner of the firm of Cronby Chirkover for 6 years. She then became and remains a partner at Fraser Beattie. She has been a participant and a lecturer in a wide variety of continuing legal education programs, including a Law Society loss prevention program on pensions and both a Lexatel and a Canadian Bar Association program on solicitor's negligence. She is a member of the Family Law Committee of the Advocate Society and was chairman of the Society's Committee on Advertising for 2 years. Bruce Alexander was called to the bar in 1967. He practiced with the firm of Osler, Hoskin and Harcourt for 5 years and then embarked on a career in government. Over a period of 15 years, he held a number of positions, including chairman of the Ontario Highway Transport Board, that's for your benefit, and was assistant deputy minister for the ministries both of transport and communications and community and social services. He is now the managing partner of the firm of Fraser and Beattie. Bruce and Nancy are here today to talk about their firm's experience in designing programs that would assist the firm to retain its women employees.
Thank you, Diana. I thought when I was listening to Lynne Sullivan about alternative work arrangements that my own career reflects to some extent the opportunity that's presented to one when an alternative work experience is offered. When I was in my 5th year at another large downtown law firm, I was very interested in doing something else for a year and was offered the opportunity to take a leave of absence to satisfy what was then something of a nascent political ambition. And what happened was that I spent a year as a political executive assistant, and that began a 15-year career with the provincial government. So I'm not really sure when I think about alternative work arrangements, in all cases, that the goals of the programs for the organizations are served, but certainly the goals for the programs for the individual in my case was. And I'd forgotten that even in those days, in an informal way, many downtown law firms were practicing that sort of thing. I'm back now as a full-time manager and having the opportunity to view management in the law firm atmosphere, which I find is very different from the management that I'm familiar with, and I'm very interested to compare notes with Henry King as to how he operates. Nancy and I have had the experience for the past year of dealing with a number of the issues that you're talking about today, and we hope that we can provide you with some understanding of how we see them from the large firm environment downtown. We are a firm that this year is 150 years old, and we've grown rapidly like most large Toronto firms, and we're expanding quite rapidly, but it's only been in the last 10 years that we've had significant numbers of women. In fact, I looked at the statistics just yesterday, and in 1977 we had only 2 women. As of today, we have 13% of the partners are women, 26% of the lawyers, and looking at other large downtown firms, the ratios vary from anywhere from 18 to about 32% of the practitioners in the firm are women now. In our firm, 40% of the lawyers' associates are women, and 50% of the law students, and I think just recently we had a class in which the numbers of women and men were approximately the same. Just as a matter of interest, I checked on law clerks as well, and 60% of the law clerks are women. I say that simply to underline the fact that the issue is very new to large law firms, because I think the statistics in other firms that I've checked in large firms are quite comparable. And as you can appreciate, firms are slow and traditional often in their responses to management issues. And I'm not sure that they have completely come to grips with this as an issue. There is a focus in large law firms on the short term as well, which is missing from other organizations, and I'd be interested in Henry King's comment on that. It's often more difficult to elevate the partners in the firm to looking 3 to 5 years out in terms of the implications of what they're doing, as opposed to the fiscal year, which usually is just around the corner. All of those things make it more difficult to manage and more difficult to deal with the longer-term fundamental issues, the strategic issues. And I certainly view women in the legal profession as an issue that large firms should be addressing in a very serious way. It came to us as a particularly serious issue because when I arrived at the firm, there was a very real focus on it as an issue as a result of the departure of a number of women partners all at about the same time. And it was looked at as something that we would have to address from the point of view of management. What we did immediately was really two things. We established two committees. One committee I'll report on, and the other one Nancy, who is as much involved in this as I am, if not more, will report on. I was involved with a part-time committee that did its investigation and came up with a part-time policy that's now in place, and I think was quite responsive to the needs expressed in the firm. And Nancy and I were involved in organizing a women's issues committee that is in the process of reporting to the firm about other issues that we saw with respect to women in practice. So far as the part-time committee was concerned, it appeared that with respect to our practice and most of the other firms that we were aware of, that there had been some informal recognition of part-time. The survey that we did, and we did quite an extensive survey of practice in Ontario and through a consultant in Ontario and the rest of Canada and some practice in the United States, convinced us that there were very few firms that had formal policies, and it was our view that we really should have something in writing where people understood what their position was and what they could ask for and didn't have to do it in any sense of asking for a favor from the firm. It was also the view of the committee that there were some situations where it would be definitely advantageous to the firm to involve itself in part-time, and the firm indeed had a number of successful part-time arrangements. In fact, even at that time, it had 2 or 3 part-time arrangements with people. We did a survey of the literature, which suggested it. It certainly didn't require that to convince Nancy or myself, but it always is reassuring, and law firms, as you know, and lawyers are always very reassured when they see what their counterparts in other firms are doing. They don't want to be too far out in front. So it's that sort of comfort that you are able to provide to the partnership by saying that another reputable firm is doing the same thing. At any rate, that was done, and it didn't seem like an untoward or adventurous move to create a policy. And we requested comments from everyone in the firm. Generally, the comments were quite supportive of the concept. And what resulted was a policy. And the policy is in operation at the present time. We have 2 women and 2 men operating under the policy arrangements. We have another woman partner who is in a different work arrangement, not part-time, but represents the same sort of, I think, flexible attitude on the part of the firm. Generally speaking, the firm needs to be convinced, as all firms will, that it is of overall benefit to the firm. Their primary concern will be the economic benefit, and I don't think we can avoid the recognition of the fact that the bottom line is becoming more and more important to firms, particularly downtown firms, that the world is very competitive. And we need to demonstrate, as I'm sure anyone else would in this circumstance, demonstrate that there is an economic benefit of some kind, and if not an economic benefit, some overriding other benefit. It's quite clear in our policy that there has to be some benefit of that kind. There as well has to be a demonstration of the adequacy of the arrangements with respect to the servicing of clients. And my own sense of that so far is that those things are fairly easily worked out, and people are very cooperative in ensuring that clients are looked after. We have technology today that allows people to work from home. We have the ability of, in a large firm, of having other lawyers spend time with other lawyers to understand their practices and to understand their client base. We haven't got to the point of job sharing, but I think that is quite possible. I had the experience when I was with the government of being involved or supervising a situation where two women as managers did job sharing, and I really felt that that was something of a first. I hadn't heard about it before, and it was quite a successful arrangement, and what I was impressed was with their ability to communicate to each other about the real issues, some of them very sensitive, around management and administration, particularly where you're in a superior subordinate relationship with staff. That would allow them to provide a consistent response and approach to the people that work for them, even though they were job sharing. And my own reflection on job sharing is that you always get at least 60 to 70% of the person who is only providing with 50% of the hours. And if employers ever knew that and knew how to use it, it could be of real advantage to them. It's very rare, I found, that the part-time person or the job-sharing person restricts themselves to the required number of hours or the required time commitment. There's usually more to it than that. There is a part of the consideration in the policy that we're required to look at is the benefit to the firm of the outside activity, and certainly if there's something involved in client development or some association or relationship that the firm would feel is an advantage to it, that would be taken into consideration. The needs of the firm itself in terms of that particular lawyer's responsibilities, the interchangeability, the specific skills of that individual at that time are looked at, and the firm wants to ensure itself that this is an appropriate time for that type of job sharing. There is a provision that also that deals with the individual and puts the emphasis on the individual being someone who has demonstrated ability. And I think that is the firm saying that if they're going into that sort of arrangement, they want to know that that is a person who they're satisfied with in the long term as a member of that firm. And therefore it is more likely to be given to someone with more seniority than less seniority, although that hasn't come up as an issue at the moment. We have taken the position